One of the fundamental doctrines relating to privilege is that of waiver. So if you have a confidential communication with yourself and your lawyer, with you and your doctor, with you and your spouse, and one of you discloses that communication to a third party, or you have that communication in the middle of Grand Central Station where anyone listening in or anyone walking around could hear you, and there's any expectation that the person walking around would have any interest in what you're saying, then you have waived that communication or the privacy of or the privilege of that communication. And then not only is it the case that the person who overheard you, the person who was informed by one of the parties to the privilege, not only can that person be subpoenaed to come and testify, but once the privilege has been waived, then a subpoena can be served on anyone, the lawyer, the client, the doctor, the patient, once that privilege has been waived. So in Bennett versus CIT Bank, we're examining the contours of this waiver. When have you waived your privilege by sharing it with third parties? The answer is usually you have. If someone else overhears this, if you share the confidential privileged communication with someone else, then typically that's going to be a waiver. But there are always some exceptions. And in Bennett versus CIT Bank, we look at one of those exceptions. And that is for a common interest. If you are sharing a legal communication about a case in which you are all mutual defendants and you all have the same concern about this same issue, then sharing that communication with those folks who also have that interest does not waive the privilege, because it's assumed that this would be like part of the joint defense. All of you could have gone to the lawyer for this advice, and to some extent, it's almost as if the lawyer is providing advice to everyone in this litigation who has that same concern, or at least that's the effect of the common interest doctrine. The really important thing to take away from this case, though, is the broad rule, which is if a third party receives that which is a privileged communication between other parties, no one at that point has the ability to assert the privilege, because once you have allowed that to be released to third parties, there has been a waiver. Now, we've looked at the limits of that, usually in the context of discovery under Rule 502. But if you have, certainly in this case, if this letter from one of the defendant's lawyers had been shared with someone who was not a party to the case, not one of the co-defendants, then that would have absolutely, unquestionably waived anyone's right to claim privilege over that letter. So waiver is a really, really, really important doctrine.